And go.
All right. This is let's get a motion to go back into a regular session. Motion by Mr. Mangus.
Second by Coates.
Second by Mr. Coates. All in favor say yes?
Yes.
Yes.
Is any opposed? All right, we're back in.
Mr. Chairman, can I frame this up for us?
Sure, let me just make one quick comment. We did go back in executive session and we took no action in the back. We just discussed possible litigation, pending litigation with options, and we have taken no action in the back, so we're coming out to consider what or if any action needs to be taken. So I'm going to let Mr. Marty give us a frame of where we are and if there's what needs to be done.
Mr. Chairman, myself and Mr. Irving were in the back with you guys in executive session, and it was about the topics that are on the back of your agenda. The notice of addendum to the agenda, A1, A, B, and C. It's about the case involving Ascension Properties, Inc. and Livingston Parish government filed in federal court. We had a very vigorous discussion about the case and about many aspects of the case. And I believe what you need to do at this point is somebody needs to entertain a motion to appoint a 3-person panel to have authority to go to the settlement conference on July 10th. And if we can get it settled, that 3-person group would have the ability to negotiate on behalf of the council and the parish to resolve the case, on the 10th. And failing that, it goes to trial on the July 29th.
I'll make a motion that the parish council forms a group to legislative body to approve hopefully a settlement to prevent trial on July 29th.
All right, we have a motion by Mr. Mangus. I think everyone understood that. Is there a second?
Second.
We have a second by Mr. Lonnie Watts. Any discussion from the council on that motion? Well, let's call for the vote.
Hold on. You going to have public discussion on this?
Yeah, we'll have public discussion. Mr. Hugh, did you want to come up to the microphone? We can, I wasn't trying to ignore you there. We got something else might be coming up after this to appoint a committee, and I was going to get people to talk. But sure, come on up,
Mr. Mangus, part of your motion would be to negotiate and have the authority to come to a final resolution, correct?
Yes, Ms.
I don't
Sandy.
think the negotiation part was in there.
Ms. Sandy, can you, on my motion, okay, thank you for the
Mr. Hugh,
elucidation.
give us your name and address, and if you don't
Henry
mind.
Hugh Harris, 36081, Highway 1036, Holden, Louisiana 70744. I am also the holder of a deed on the property y'all are discussing. It's in Livingston Parish Conveyance Book 1520, page 717. Y'all had a lot of discussion about a fence earlier. Mr. Irving kept speaking to equal protection for all the people. And I'm curious about how you are taking a non-owner of property who can't relate to any deed in that courthouse, and you're going to enter into a negotiation of settlement that could involve that person beginning to develop property he cannot show a deed or title to when I am here with a deed and title and objecting to it.
Well, Mr. Harris, that's a good question. We're here to talk about a lawsuit that somebody has filed against the parish, okay?
Absolutely.
And this is because of a stop work order,
Absolutely.
I believe, that the parish had implemented. So they filed a lawsuit against the parish, and it's racking up some serious attorney fees and so forth. Now, I don't even know who owns the property. I just know that we have a lawsuit pending against us from someone that we're going into court. It doesn't, I mean, to me, it doesn't matter if this property's in Nashville, Tennessee, or California, or 4-H Club Road, or who even the owners are. That doesn't change the fact that we have a lawsuit that we have to deal with. I mean, I would think that as far as legal and title stuff, wouldn't a title attorney fix the problem of determining who owns it? Wouldn't you get the title attorney to determine that?
The title attorney?
Yes.
No, it's a judge.
Have you got a judge to rule that?
We are in law litigation right now, John. It's being sued right now to determine who owns the property. And Ascension Properties would like you to settle this lawsuit before the Livingston Parish judge says, I own the property. That's true. Now hold on. You brought up litigation. Right now you have one lawsuit during which each one of you have immunity. You have qualified immunity because you're within the course and the scope of your duties. But the people who claim to have this property, who are now my title, my chain of title, involves a United States land patent. It's not like a purchase deed from John Doe. This is a vested right from the United States Congress. You do not have any authority to violate United States law. It puts you outside the course and scope of your duties, which removes that immunity. And all of my co-owners, you have one lawsuit now. You give this property that actually belongs to all these other owners, and you don't have immunity against them and their lawsuits.
Let me ask you this. We're not giving this property to anybody. It's not ours to give. It's not, we're not declaring who owns the property.
You are declaring that somebody is going to build on it when who owns it is in dispute. Your ordinance requires your building permits and everything else be given to the owner or the agent thereof. That means if the land is in dispute, you don't have an ordinance that allows you to let building, development, thinking about development, or anything else go forward.
I don't have anything else to say. I don't know what to say. Mr. Mangus?
Anybody ask a question?
Mr. Gentleman, can you?
Harris.
Yeah, not Mr. Harris, I'm sorry. Our two attorneys, Mr. Irving, and can you speak to this?
The only thing that I've got to say about this, and this is not against Mr. Harris, I think he's a fine gentleman, and he's got his right to assert any claims he wants to assert, but he made these arguments in our federal lawsuit, and the federal judge, Judge Dick, dismissed his claims. It might have been Judge Johnson, the administrative. It was Judge Johnson, the magistrate judge, dismissed his claims from that lawsuit. Now he may go and file something somewhere else and try to assert whatever he wants to assert, but he's not in the lawsuit that we're dealing with that's on the back of this agenda. So that's all I can say. And with regard to the title and all that, that is a very, very complex issue that goes back to the 1800s and the United States Supreme Court and what happened for years and years and years after that. So I don't know what some judge would do with that. Certainly, Mr. Harris is a determined person, and I respect that, and we're probably going to find out what some judge would do with that. But with regard to opening you guys up to personal liability, I beg to differ with him on that topic.
The only thing I would add to that is that it might well be possible that if we do reach an agreement we'll be negotiating with Ascension, but the Livingston Holdings is actually the applicant for which is the people who say they're the owner of the property. We could potentially put in an agreement a provision that says that if there's a final judgment from a court of record that says that they don't own the property, then the deal fails.
Ooh,
good point.
So basically, if we do go in and talk to them, we could make that stipulation that if Mr. Harris is rightful owner, or then and that this whole thing is off, and
there's an adjudication that they don't own the property, then they don't have the authority, and the deal fails. I think we could put that in the agreement, and I don't think there'd be a problem with getting it, and we certainly would try to do that.
okay.
Mr. Harris, have you sued your group of owners?
Yes. I'm in litigation right now in 3 different lawsuits dealing with this property. And I would refer you to a transcript from my last hearing in the 21st Judicial District in front of Judge Ricks, where she asked the attorney, and this is on the docket in the parish court if you care to look, but on page 14 in this transcript, the judge asked counsel for Livingston Holdings, how are y'all going forward if you don't have all of those heirs lined up? She's referring to my co-owners. How are you going forward with building homes? That's a judge's position.
But
Now
she's a
this-
state judge, correct?
She's absolutely a state judge.
Yeah, and this is from what I understand, this particular one is federal.
In federal court, this is Judge Johnson. He did not rule on my claims. He ruled on my motion to intervene. And what he wrote is this. Not only does the current litigation not impede his ability to protect his interest, but in fact, Harris is currently protecting that interest through a more apt litigation. Now, it's common sense to say if Livingston Holdings doesn't own it, the deal falls through. But how much is going to be done pursuant to that deal while I'm in 2 or 3 years of litigation, and then the litigation rules on my side, the deal falls through, but my property's gone.
But you would,
You'd probably be reimbursed for it, wouldn't you think?
We can't.
or you'd probably own it.
I mean, you understand what I'm saying? If they go in there, and correct me if I'm wrong, and I'm just speculating. If they go in there and build 400 houses, then, I mean, you've got a pretty good royalty coming to you, seem like to me, if they rule in your favor.
Except that I am not interested in the
Yeah, well, I
property
understand that,
for
yeah.
houses. I have a non-pecuniary interest in the property. I grew up on that property. Every tree on that property is valuable to me beyond money.
Yes, I understand that.
And I want it left alone until my deed is in the courthouse. You are bound by that deed.
Harris,
Yes, sir.
I spoke to you on the phone.
Yes, sir, many times.
Didn't you tell me you had a land patent which takes precedence over a deed?
Yes, sir.
Didn't you tell me that you had
Yes,
that?
sir. The land patent that I have is not subject to acquisitive prescription, which is adverse possession or squatter's rights. We have a law in Louisiana that says if you get on property for 30 years, nobody kicks you off, you own it. And that's the position Livingston Holdings has taken. But certain land patents were precluded from that being allowed to happen. I have those precluding land patents.
Have you filed an injunction to get them to stop?
This was in the case for an injunction, and the judge actually said because I had turned in a motion which required a memorandum. I filed the motion and included an incorporated memorandum. She said that did not suffice as a memorandum, so I was not allowed to put on evidence in that hearing. But even in the absence of evidence, she's asking Livingston Holdings, how do you build when these other heirs own the property? And y'all want to enter some level of settlement that, I don't care if they dig a ditch. They're destroying my property, and this is not about having a deed. The United States Supreme Court said in 2015, we're not talking about ancient law, the land patents issued by Congress to individuals undoubtedly vested a right in the patentee. That's not a conveyance. That's a vesting of a federal right. It's dressed up like a land dispute. But in the end, it is merely someone saying, I have a federal right and I want it recognized. And it's going to take a little while because it's got tentacles and stuff. But I am situated exactly the same as the criminal defendant that walks in and says, I can't afford an attorney and I want one. There's not going to be 40,000 years of case law to figure out whether he can get one or not. He's going to get it. I have an act of Congress signed by the President of the United States saying I own that property. You don't have a state court can turn that over. It's just taking some time.
Mr. Harris?
Yes, ma'am.
I think nobody sympathizes with me more than you. I'm from District 5. We are not judge and jury. We cannot rule on this. We're going to need a stop order from a judge. There's nothing that we can do. Let me tell you, if anybody sitting up here right now has tried harder, it's me.
I believe you, Ms. Aaron. The question I have is this. The land is in dispute. You go to the courthouse right now, there's one title claimed by Livingston Holdings. There's one title claimed by Henry Hugh Harris, and you're absolutely right. You have no authority to judge or be a judge and jury over which one of those is good. That belongs in the 21st Judicial District. You don't have authority to tell somebody, you can't show us a title, but go ahead on that property anyway, and if somebody else owns it, we'll work it out later.
Prima facie, I agree with you. The problem is that we have been sued, the parish president, the parish council, in federal court, and we have a court date, come hell or high water, on July 29th.
Yes.
And they have racked up many, many millions in legal fees, and if we don't respond to it...
Well, what you say, okay?
If we don't respond to it,
Let me just say this. Sorry, John. Mr. Irving made a comment that in the negotiations, we can put in there that if the land is owned by someone else, then we'll take that further and further that issue itself. But I don't think we should stop what I'm with you 100%. You and I talked on the phone, but I think we need to include that in there, and we'll do it, include what he's saying in the negotiations. And if the land is not owned by Livingston Holdings, then the whole thing is off. From what I understand.
Okay, but how much is being done before we determine Livingston Holdings doesn't own it?
We won't know that until we go into negotiations.
Then there's no protection.
But what I'm saying is that will be in the negotiations. They'll basically state, do you own this property? We have a deed that says somebody else owns it. If it's proven that you own the property, then the whole deal is off. That's what I'm saying.
How much will have been done pursuant to the deed before the deal is off?
I don't know. That would be another lawsuit then, I guess.
It's going to be about 18 of them.
Can I make a statement, please? Ms. Aaron was absolutely correct when she said that, and you know this, you're a smart man. I mean, the last name's Harris. What can I say? We cannot thumb our nose at a federal court. We have to respond based on what that court gives us. You have reached out to that court and tried to be heard as well and put a halt to this. Yes. We would absolutely have loved for that to have happened. We would love for you to become the new owner of it, because we would like to go out there and do a picnic under the oak trees with you. But unfortunately, we are where we are. And I think Mr. Steve was correct in trying to put some provisions in this settlement that helps from your standpoint with the thing. Now, other than that, we can't help from your standpoint because we have no judgment that says that it's your deed. And if someone else walks in with a suitcase full of papers and claims as well to own it and has a deed in their hand, we can't tell them that they own it, just like we can't tell you that you own it. So we have to, as a body, have to respond to this lawsuit and move forward with it. Unfortunately, they didn't allow you to have your portion of it, and then hopefully you are successful. But beyond that, we can't. We're not going to be able to do anything with this tonight. Okay. From your standpoint, I wish we could.
But I don't think anyone is realizing that you are ruling, I don't have a good deed.
No, sir. I'm asking you to show it to me, but you can't. No. You can show me any paper that you want, but we're asking you to show me a judgment from a judge that says you own it. If you could do that, you wouldn't be in the lawsuits that you're in now, because you're still trying to prove to the court system to rule in your favor to where you'll have that judgment that goes beside your deed. And once you do that, you're good to go. But we can't continue to go down this rabbit hole, Mr. Harris. I'm
well, my question is this.
Yes.
Livingston Holdings has sued me in reconvention to get their title declared good. So until the judge declares theirs good, why are you giving them a permit?
Well, I promise you that it will come up in conversation. But we, again, the reason why we are going to them is because the federal judge said, show up.
Okay. The federal judge said show up and discuss settlement.
That's right.
Okay. You are not ordered to settle.
That's a decision.
You're
that we
absolutely right.
ultimately
We're not
have to
ordered to settle. We could not settle, but we do have a court date, July 29th, come hell or high water.
make. So we got to, unfortunately, and I appreciate your passion, I appreciate your desire.
Absolutely.
And your drive for it, and I really do hope that you prove your case, not only for you.
No, sir. I want to be real blunt with you.
But for the parish.
You really hope I don't.
That sounds like he's after the parish.
And the people who are waiting, the people who are in the United States Air Force tonight and can't be here and are supposed to have everything told before they lose their property, that's good for you.
We appreciate it.
But I do appreciate your time.
Thank you, sir.
And it's amazing that you took an oath to uphold the Constitution and the laws of the United States. And every one of you has received an email that contained acts of Congress signed by the President of the United States, which has full force and effect of federal law. And you're setting it aside because of money. Thank you.
Hold on, Mr. Harris. I want to say one thing.
Yes.
I think we all can testify and agree that what you're doing, you're trying to prove your ownership of the property. We're not discrediting that, no. But I don't agree with the lawsuit threat. You can work with us on your issues that you're having, and you and I had a conversation, and I told you that I'm behind on what you're presenting, but I don't appreciate the threat because we've done nothing but be kind and willing to work with you in this situation, but there's no need for threats. I'll just tell you that.
I'm not threatening at all.
You just threatened.
Just now.
You said that we're breaking federal law.
You are breaking federal law.
Well, we have a federal lawsuit. We have been sued. We have to show up. That would be breaking federal law if we don't.
Again, we're willing to work with you, but I don't appreciate the threats.
If I misspoke, I'll take it back. But I came here tonight to work with you. I've sent any of your paperwork. I've talked to any of you who would listen. I've asked time and time again, ask me questions, play devil's advocate with me. But it's not that you're invalidating my claim or you can't validate it. I totally get you're not judges. And you do not have the authority to say this title's good and this one's not. And when you are letting somebody go on that property before they come in and say, I have a good title, then you are in violation of your ordinances. And it's not for you to litigate or adjudicate. That belongs to the judge. The very least you should do is hold off until either Livingston Holdings or myself is told to remove our deed from the courthouse.
We have a time limit, though. We have a court date.
Then you make a continuance and extend the court date.
That's a very good, valid point. When that question was asked, do you want to address that?
Sure. I'd just like to say this, too, just to clear some things up. Mr. Harris made some of these arguments to the federal court, and the magistrate judge didn't let him intervene, removed him from the case that we've been discussing for the past hour, removed him from that case. Now, he certainly has a right to litigate his issues and try to prove up his title and everything, and I think that's probably going to happen, at least that process is going to happen in state court. And it's, like he said, it's probably ongoing right now, maybe from his side and from the Ascension Properties side. But the bottom line is this: we can't stop the federal judge from setting the deadlines that she set, and we're under time constraints to move forward, very strict time constraints. We talked about that tonight. That's why we're in the process of appointing this 3-member panel to go to the settlement conference on the date that the court set. And if it gets resolved, it gets resolved, thank God. And if it doesn't, then it goes to trial on July 29th. So that's where we are with regard to the federal procedure and the federal lawsuit. Mr. Harris's claims have really nothing to do, as somebody said earlier, about the nature of this lawsuit. The nature of this lawsuit is over a stop work order. It's about an injunction, and it's about Ascension Properties and actions taken by this parish, and you guys and Mr. DeLapp. So that's the framework of this lawsuit. So you're absolutely correct. This lawsuit's got to move forward, just like the judge said, and it's got to move forward on her timeline. And she set the timeline. It's not real attractive, but she said it, and we got to comply with it. So that's where we are.
I've got one last thing. Y'all have been here long enough.
Did you find out anything? Did you find out anything when you went to Pennsylvania worth talking about there? Okay, what was that?
Like I told you, I've got about 3,500 pages of evidence. Because when they sued me in reconvention, they named all of these other successions. So I've been around the country getting all these other wills that left this property to these other people, and we'll get to that in the litigation. But he has referred several times to me not being allowed to intervene. This is the magistrate judge's ruling, and he specifically states, the question of disputed ownership is not before this court, and this court makes no determination in that regard. Again, this court makes no determination as to the rightful owner of the property. That question is before the 21st Judicial District in Livingston Parish. He goes on to say that given the pending state court litigation, the 2023 litigation between the current parties preceding this one, and the expedited schedule of this litigation, it has nothing to do with the quality of my arguments. It has to do with them wanting to hurry up and let Ascension Properties start before the 21st JDC tells me I own the property. That's the only reason.
Let me ask you a question. If we don't do a settlement and we go to trial and the judge rules that Livingston Parish Council or Livingston Parish government cannot prohibit a work by from this federal judge rules that we have to let them go in there and do what they want to do.
Right.
Okay?
Right.
Then at that point, what do you do then with your claim?
At that point, it would probably become injunctive action against Ascension Properties. Ascension Properties has a cease and desist letter from my co-owners that they're not supposed to even pursue anything with y'all. This is in violation for them to do it. But that's okay. Know it. Everybody asked me, did that come
if a judge rules, should we at that point fight the federal judge and keep them from coming on your property?
Well, I'm the taxpayer in Livingston Parish, and I think so.
So we should go against the federal judge's ruling and prohibit them from coming on your property?
Yes. Because my property is protected. You want them on, John, I'm
just asking you, so you think we should...
It's what's legal.
I mean, we got a federal judge telling us that do not stop these people from getting on that property,
yes.
and rules in that,
yes.
and you saying, never mind the judge,
because
they're wrong?
There is a case called Fitzgerald, where the First Circuit, it has long been held that a judge and a court do not have jurisdiction to order a local official to do something that is within that official's discretion. Now, I know that hasn't been brought up this time, but in the 2023 litigation, it's exactly what Mr. Moody filed, particularly when the concerned citizens of District 5 tried to take action and make then President Riggs not proceed with Deer Run. His motion to dismiss that litigation included these statutes that you cannot be ordered because you have the discretion. If it's not within your discretion, if a judge can tell you you have to do it, then I don't come to you for anything. I just go get a judge. You don't have any discretion. That is the case law, and it is reversible error if he orders it. Now, that comes from me, but yeah, Mr. Moody had the same position. So, yes, you have an absolutely appealable case, and I think they would tell you that, except they're probably not going to say absolutely.
Well,
but I understand. Look, I appreciate y'all letting me stand up here and drive along. And I apologize to you, sir. If that was out of order, I'll take it back.
I think you're doing a wonderful thing, and trust me, we're not supposed to take sides, but I think we'd much rather have you and your family. But I'm with Mr. Goff. I just wish you would have an injunction. I mean,
Okay. Well,
we're staring down the barrel of a federal lawsuit.
I'm not going to talk about my litigation too much either, but I'll be back. And
Thank you, Mr. Harris.
Thank you.
Mr. Harrison, thank you for all the work you've done. Diligent.
Okay. All right, so I think there was a motion, if I'm not mistaken, the motion, let's see, was by John Mangus, seconded by Lonnie Watts, to create a 3-panel committee. Did we vote on that?
Negotiate.
No.
Okay, yeah.
Do we what?
Go ahead, you want to reword that, or do we,
Yeah,
did you get that?
Yeah, the motion he had was to negotiate with the other side at the hearing on July 10th, and to have the authority, if it's prudent and the terms are right, to settle the case on
with the
behalf of the parent.
stipulation that who's ever determined the rightful owner. So if Ascension Properties is not determined the rightful owner and Mr. Harris and his group is, then that wouldn't hold up, right?
And we suggested that we would put such language, insist that such language be in the
If there is
settlement
a
documents.
settlement. If there is a settlement.
If there is a settlement.
Okay.
Is that fair?
All right, we had a motion and a second then. Any more discussion, Ricky?
There's a three-member board.
I'm fixing to pull, let's go ahead and vote to do it, and then I'll make the appointment if y'all want.
That's what we're creating a three-member board.
Ricky,
The chair is going to sign.
I'll make the committee.
That's correct.
Yeah, Mr. Sandifer, I believe.
Jamie Sandifer, 24411 Omaha Harris Lane, Denham Springs. I'm a member of the Master Plan Committee, not here representing the Master Plan Committee, but I just had something I wanted to point out because through Master Plan I have dug pretty deep in this. Livingston Parish Ordinance 19-27. Add section 226. Future parish council decisions regarding growth and development shall be consistent with the comprehensive master plan, or the plan should be amended via the process outlined in the plan. The master plan has not been amended. If I go to the land use maps, that is page, I just pulled my tab off. To page 29 of the master plan, the property in question is clearly marked out as rural and agricultural. So barring any change to the master plan, any settlement that allows a development to go forward in this area would be a violation of parish ordinances. So that's,
Violation of what?
A violation of parish ordinances.
Parish ordinance, okay.
I mean, basically, you'll be breaking your own law if you allow a development to go forward on that property. So just hope y'all take that into consideration in those negotiations.
Thank you so much, Mr. Sandifer. Maybe we should put you on there. All right, let's call for the vote. Miss Sandy?
Mangus.
Oh, what is this to vote for?
To appoint a 3-member committee.
We're not naming them yet. We're just.
Well, and to give me the authority to name.
Gotcha. Okay. Sorry.
Mr. Watts? Yes. Mr. Goff?
Yes.
Mr. Shavers?
Yes.
Mr. Coates?
Yes.
Mr. Taylor's absent. Mr. Erdy?
Yes.
Mr. Wascom?
Yes.
Ms. Sandifer?
Yes.
All right. I'll appoint 3 council members. First one I'd like to put is the person who has fought like tooth and nail more than anyone else, Miss Erin Sandifer. And the second one.
Appoint yourself first.
I'd like to appoint Mr. Ricky Goff. And then for the third one, any volunteers?
Yeah, let me a volunteer.
All right. I'll appoint myself as the third one.
Illustrious.
So if y'all have any problems with that, please say so now or forever. Hold your peace.
I have a problem, but I'll do it anyway.
Okay. Is there a motion to adjourn?
Yes.
Motion to adjourn.
By Dean Coates, second by John Mangus. All in favor say yes.
Yes.
Motion carries. I hereby declare this meeting adjourned.